sufficient to introduce Sir. However, to do the formality, Sir is a senior advocate at Karnataka High Court. Sir has been the Advocate General of Karnataka government several times. He shot to prominence nationally in the disproportionate assets case against the former Chief Minister of Tamil Nadu, Ms. Jayalalitha, where he pursued the case as a special public prosecutor and special counsel, taking to its logical end despite hardship and threats. He was selected as one of the top 10 lawyers of India by the Bar Council of India in 2017. We welcome you, sir. I request our Dean, Professor Dr. T.R. Subramanya, to welcome Sir with a bouquet.
Dr. T.R. Subramanya and my Shri Pai and dear students. It gives me great pleasure to be in the midst of law students, because I was a law student more than 65 years ago. It was between 54 and 56 that I studied law at Madras Law College. The method of teaching, subjects, and everything has changed so drastically. In our days, there was no moot court competition. There was no group discussion, nothing. The lecturer will come and give lecture. It doesn't bother we have understood or not. Those who want can take notes. Others need not do anything. And attendance is very free. There was no problem. And we had a lecturer who was teaching Evidence Act. And he was saying, in a recent decision in 1917 Privy Council, we were wondering how in 56 he says recent. Then we found that was no notes he had written when he was a student, and he was continuously doing it every year. And even though he used to regularly hold classes up to the end of the year, he used to come to only up to section 29 of the Evidence Act. The rest of it, our regular one, Professor Balasubramaniam, he used to take up the class, and within 2 months he used to finish the other portions. And also, that particular professor, he always used to come 10 minutes late, and he used to go back 10 minutes earlier. And he was very liberal in giving attendance. Many students, after he went to the chambers, used to go and say, "Sir, I came late, please give me attendance." He would grant. Once 4 students came and said, "Sir, please, I am sorry I came late." Then he said, "Today I have not taken classes at all. I have just come from my house and you are listening." This was the state of affairs in our college days. Anyway, when I see law students, I am reminded of our days. And whenever even the invigilators, 2-3 students, copying is alright, but you are not sure that his answer is correct. So they used to discuss. Then the invigilator, the maximum reprimand was, you see, we want individual opinion, not full-time decision. Therefore, please don't do all this. This was the state of affairs. Anyway, now subject chosen is separation of powers and the need for restraint. Since the train is running very late, we will try to catch up and increase the speed so that we will try to finish it as early as possible. I think Mr. Pai also has done the same thing. Now, as you know, our constitution is considered as one of the best federal constitutions in the world. And very eminent jurists and stalwarts all deliberated for 2 years, 7 months and few days and gave to ourselves our constitution. And no doubt Dr. Ambedkar is the architect of the constitution. Dr. Rajendra Prasad was the chairman of the drafting committee and also the law minister at the time. But one name which we must always remember when we talk of our constitution is Sir B.N. Rao, that is Benegal Narsingh Rao from Karnataka. Now he was the constitution advisor to the Constituent Assembly, and his efforts have led to the constitution. Though ultimately the drafts were changed and discussions took place, the original draft was prepared by him. He was an eminent jurist. He was a judge of the Calcutta High Court, and later also he held very high positions. In fact, without going into any details, in only one sentence I will tell about his erudition. The President of United States said that if ever I am given a chance to appoint anyone as a judge of the Supreme Court who is not from America, Sir B.N. Rao will be number one in my list. That's what he said. And ultimately B.N. Rao died when he was the judge of the International Court of Justice in Switzerland. And on his death, breaking all protocol, Pandit Jawaharlal Nehru requested the Speaker to permit him to make obituary reference, which is made only in the case of demise of a sitting or retired member of the House. But in this case, they deviated and gave. Therefore, I always say we must remember the great contribution made by Sir B.N. Rao in preparing our constitution. As you know, there are three organs: legislature, executive, and the judiciary. Each one of the organs is equal to the other. There is nothing like one is superior to the other, and their functions are all well known. It can be easily inferred by reading the Constitution. Though they are all equal, the judiciary is certainly in a more advantageous position and gets a sort of superiority merely because of the nature of its functions. One important thing is why it is considered that each organ should act within its own sphere, which is earmarked. You should not trespass upon or encroach upon the power or area specified for the other two organs. Now, the responsibility of seeing that each organ functions within its own sphere and doesn't encroach is also on the judiciary. This is the additional power which the judiciary has got. Therefore, it is in an advantageous position, and therefore our Supreme Court is considered as one of the most powerful Supreme Courts in the country. It has got original jurisdiction. It has got dispute between the states. There is provision for suit, and Article 32, as you know, approaching Supreme Court itself is recognized as a fundamental right, and the power under 136 is very vast. In addition to all this, they have got 142. They can pass any orders that they want. Thus, this is the position of the judiciary. Now, one important thing is, though it is not specifically stated, it has to be assumed, and there is no dispute, that each organ should function with its own sphere and should not go outside it. And this is recognized by everybody, including the Supreme Court. The Supreme Court in 2005 itself said, under the Constitution, the legislature, executive and the judiciary have their own broad sphere of operation. It is therefore important that these three organs of the state do not encroach upon the domain of another and confine themselves to their own. Otherwise, the delicate balance of constitution will be upset. The judiciary must therefore exercise self-restraint and eschew temptation to act as a super legislature. By exercising restraint, it will only enhance its own respect and prestige. Judicial restraint is consistent with and complementary to the balance of power among the three independent branches of the state. Then in 2002, again they said, Supreme Court also does not consider itself to be an imperio or would function as a despotic branch of the state. If all the functions of three come into one hand, then he will be a despot. That is not to be encouraged. Then, in the case of Lakshmi Kuti, they said, special responsibility devolves upon the judges to avoid an over-activist approach and to ensure that they do not trespass within the spheres earmarked for the other two branches of the state. Now, with this position, we will see what happens if one encroaches. If the legislature or the executive does anything in excess of its powers, immediately you have a remedy by going before the judiciary. The judiciary has got sufficient power to strike down and nullify any executive or legislative excess. Even a law passed by Parliament, even unanimously, the court has the power to strike it down and even grant interim stay, though generally no court will stay a legislation until the validity is considered in detail, but the power is there. If they find that a piece of legislation is atrocious and unconstitutional, they can stay and quash it. But then what happens if the judiciary itself does it? It encroaches upon the area of the legislature or the executive. Then what is your remedy? There is absolutely no practical remedy available. Therefore, it is said, I think Justice Stone of the Supreme Court, American Supreme Court, said, while unconstitutional exercise of power by the executive and the legislative branches of the government is subject to judicial restraint, the only check upon our exercise of the power is our own sense of self-restraint. So judiciary itself must realize this self-restraint. And I am also tempted to quote one extract from late Chief Justice Ismail Muhammad of South Africa. They said, but the difference is this: the abuse of legislative or executive power can be policed by the independent judiciary, but there is no effective constitutional mechanism to police the abuse of judicial power. It is therefore crucial for all judges to remain vigilantly alive to the truth that the potentially awesome breadth of judicial power is matched by the real depth of judicial responsibility. Judicial responsibility becomes all the more onerous upon judges constitutionally protected in a state of jurisprudential solitude where there is no constitutional referee to refute their own wrong. Therefore, self-restraint on the part of judiciary is more important than all the rest. Having said this, let me go to the next point, that is, generally, as between the executive and the legislature, there is no scope for any conflict or one acting in excess. As you know, the political executive is part of the legislature and they are elected and they are responsible, so they have to act in cooperation. There is no scope for that commission. Similarly, the legislature stepping into the judiciary are also very rare. Only rare cases. You can't say there are no cases. A legislature cannot say a judgment of a court is wrong. That will be trespass. But the legislature can always try to overcome a judgment by passing a legislation, correcting the error which the court has pointed out by enacting that notwithstanding any decree or judgment of the court, this will be the law. It was only in such cases that there is scope for a contention that the legislature has interfered with the power of the judiciary. But even there, in the case of that conflict also, ultimately it is the judiciary which is decided. It has always decided in its own favor in most of the cases. And the latest case is relating to the tribunals. You must have been seeing in the newspapers. The number of tribunals are constituted, transferring the power of the judiciary to the tribunals, which are quasi-judicial bodies. Now, the Parliament has power to make law regarding the conditions of service and other requirements of the tribunals. Now, the judiciary, Supreme Court said the tenure of the chairman and members must be 5 years. But Parliament said no, it will be 4 years or 3 years. And thus there is a conflict. Now the Supreme Court said, since the tribunals are part of the judiciary, our judicial power is transferred to them. You are prescribing the qualifications and tenure must be consistent with our views, and you can't do as you please. Now the executive says, what should be the period, tenure, 3 years, 4 years or 5 years? It is our privilege. You can't interfere. But the judiciary says otherwise. And this fight is now before the Supreme Court. The other day, those who have been appointed and given only 3 years tenure approached the Supreme Court and said, we are entitled to 5 years, we should not be terminated. But the Supreme Court has taken over the matter. We will examine this question, but they refuse to grant interim order. This is how, in a few cases, there is such dispute between the legislature and the judiciary. In fact, the judiciary has become so powerful that even with regard to the matters relating to proceedings of the legislature, the judiciary has taken an upper hand. Some years back, where two persons were claiming to be chief ministers of the state, that is Jagadambika Pal case, Supreme Court directed assembly shall be called at 11. They appointed an interim speaker and said proceedings should be like this. Strictly under the constitution, courts have no power at all. Within the legislature, it is the speaker who is the ultimate authority. But that way, these things have happened. And another, therefore, the difficulty of access by other two which are rare. And even if it happens, you go to the judiciary. But the difficulty arises where the judiciary oversteps. Now, judiciary overstepping its towards the legislature is also, as I said, there. But the most of the problem today is judiciary taking over executive functions. This has become a major problem which we are facing today. The judiciary enacting law is also a menace. The legislature the judiciary has no power to make law. Their power is only to interpret the law. Now, as all of you know, whenever the judiciary makes a legislation, it is generally not challenged. For instance, Vishaka case, you all know. The judiciary has laid down the law. Even in many other matters, judiciary gives some directions, and if it is Supreme Court, they say what we now say is law, because Article 141 says so. So whatever directions we have given, treat them as law. This is how the judiciary has been entering into the field. In fact, some time back, in Unnikrishnan's case, virtually judiciary took over educational field and prepared a scheme, payment seat, government seat, and etc., how it should be done. Having prepared a scheme, ultimately Supreme Court found it is impossible for it to manage, because every day there were large number of writ petitions. You see, this is one danger where Supreme Court makes a law. If anyone else makes a law, you go to the judiciary. High Court can strike down. High Court can say it is wrong. But if the Supreme Court itself prepares a scheme, they don't have expertise in the matter of legislation. But still, wherever it was for the benefit, as in the case of Vishaka, people have tolerated it because though it is in excess of power, it has not brought about any bad result. Then the latest instance of the legislature making law is only last week, Allahabad High Court finding that the cases relating to dowry and cruelty, 498A, the general impression is these provisions are totally misused and frivolous cases are registered and the cases are foisted and arrests are made. So what they have done is, they said whenever there is a case under 498A and relating to dowry, a committee will be constituted and that committee will try to mediate. For 2 months, the case should not be registered and the person should not be arrested. Now, this is what the High Court says, totally contrary to the Criminal Procedure Code, which authorizes registration of the case and power of the investigating agency to arrest. Question is, only 2 days back I saw a big article that though their intention is good, High Court could not have made this legislation which renders the provisions of the Criminal Procedure Code redundant. So these are the matters relating to encroachment on the power of the legislature. Now coming to the other you see, generally, judiciary will not be interested in taking over the executive functions. That was the position. And anybody approaching the court always till 1970s, he must have locus standi. He must be an aggrieved person to go to a court. But for the first time, this concept of PIL came into force. The Supreme Court, relaxing the requirement of locus standi, said any public-spirited person could file a case for the benefit of those who are otherwise unable to approach the court for various reasons, either illiteracy, ignorance, poverty, and mainly cases of bonded laborers, women, children, prisoners in jail. Regarding their welfare, some petitions were filed, entertained, and this sort of a public interest litigation really helped many people. But unfortunately, and the other is where the government gives a largesse to somebody or his own political party man. Today also you have seen some property worth crores of rupees are allotted for a favorite of the government for a couple of lakhs of rupees. In such a case, and also in the case of corruption, that so much of money has been paid, neither the person who has paid the bribe nor the person who has received it will come to court. It is only a third party who could come. So therefore, this was permitted. But in course of time, we have found that it has become one of the biggest evils, very seriously affecting the performance of the judiciary. Most of the time is taken in dealing with PILs. Of course, in this matter, there may be difference of opinion among many people, because according to me, some so-called activists, it has become a profession. Even for some lawyers, it has become a profession. Now, in the matter of specialization, this is one more. He is a specialist in PIL. And in many lawyers feel, oh, this case, it is your individual grievance, court may not entertain. So, you get somebody to file it as a public interest litigation. This has become virtually a menace, and the court itself is terribly worried about these things. And at least the petition must have some public interest involved, otherwise you can't. But situation came to such a stage Some 3 days back, Bombay High Court entertained a petition regarding change of name of the metro station. But only condition they put was you deposit 1 lakh rupees. I don't know if the idea was to dismiss it with the cost of 1 lakh or otherwise. But the point I am making is whether the airport, name of the airport, or the location of the airport, name of the bus stand, location of the alignment of the railways. In fact, couple of years back when this metro train work was going on, I was appearing for the company which was constructing this metro. Large number of petitions only regarding the location, whether it should be on that side or this side, and secondly, the name. To this extent, if you go, what the High Court is to do, if they entertain such petitions. But it is not only the petitioners are to blame. Courts are also equally to blame. Not all, but at least some. Some judges have great interest only if it is a PIL. And matter is not immediately disposed of. I will just give one illustration. One petition is filed. In Indiranagar area, there are so many restaurants with loud music and all that. And a petition is filed. Police are not taking action. There is noise pollution. Make the pollution control board a party. The police are not acting to see the license. Make them also a party. From the health point of view, the health department of the corporation and the commission was not right in giving that license. So he is also made a party. And all these are asked to submit every month status report. What action you have taken, how many for the equipments you have, like this. You see, is it possible for the judiciary to run the administration? In fact, at the start of the COVID itself, I wrote an article that whatever enthusiasm is there, at least in the matter of COVID management, courts should not interfere and they should restrain themselves. Even if they don't give any direction, merely calling for information will upset the entire machinery. Suppose the question posed is how many beds you have, how many with ventilator, what is the quantity of medicine available for what purpose. You give all these statistics, give it district wise or taluka wise. The whole machinery, are there to treat the patients who are there or to fear of contempt. Therefore, this is why I say the judiciary must restrain itself in entertaining these PILs which consciously or unconsciously prompt the judiciary to trespass into the area of the executive where if judiciary does it, there is no remedy. Of course, if it is the High Court, you can go to Supreme Court. But technically correct. But how many cases, how many people can go if there is to be continuous interference and taking over of the and most of the as on today, though beginning PIL means public interest. Now P stands for anything other than public. It may be political, private, personal, publicity, and last is paisa. Now the two are together, RTI Act and PIL. You go and get information. In fact, I am one of those who felt that this RTI is also causing grave damage. There are so many things in the administration which anybody should not come and get it. One day I was shocked when I was the Advocate General that I had given a sincere opinion to the government, and on the third day when the matter came out, my opinion was produced before the judge. The government is advised like this. You see, this is the way. Now, you get some information about somebody and then threaten him with PIL. You see, I have got this information about you, and if you don't pay me so much, I will file a PIL. This is the combined effect of all these things. Now, I would just read few sentences from two judgments. Justice Verma, Supreme Court. Judiciary has intervened to questions such trivial things they have intervened as mysterious car racing down the Tughlaq Road in Delhi, allotment of particular bungalow to a judge, specific bungalows for judges' pool, monkeys capering in colonies, stray cattle on the streets, clearing public inconveniences, levying congestion charges, peak hours at airports with the traffic, under threat of use of contempt power. These things are all taken use of. Misuse of contempt power to force railway authorities to give reservation in a train is the extreme instance. A magistrate issued contempt notice sitting on the railway platform. The courts have recently, if not clearly, strayed into the executive domain or matters of policy. In matters of policy, you have no right to intervene. The order passed by the High Court in recent times dealt with subjects ranging from age and other criteria for nursery admissions, unauthorized schools, criteria for free seats in schools, supply of drinking water, requirement of establishing world-class burns in the hospital, and like so many silly things. The not only petitions are filed, but they are entertained. And another thing to be noted is, judges also must know that they are not experts in all the fields. They may be very good in law. Even that I don't know, because they say ignorance of law is no excuse. Ignorance, it is said, but they say ignorance of law is no excuse. One exception is for judges. They need not know law. Had they known law, why is there appeal and revision and a reversal of the judgment? Therefore, judges should not think that they are experts in every field. In their own field, it's all right. Therefore, even in the matter of medicine, can they say this is to be preferred to that? So, this is what one Chief Justice Negi has said when he was confronted with some matter. I have very few illusions about my own limitation as a judge. I am not an accountant, electrical engineer, financier, banker, stockbroker, or system management analyst. It is the height of folly to expect judges intelligently to review a 5,000-page record addressing the intricacies of a public utility operation. It is not the function of the judge to act as a super board with the zeal of pedantic schoolmaster, substituting its judgment for that of the administrator. We should not enter upon fields in which we are not competent. Then, because of these failures, genuine litigation suffers. I will read only one sentence, it's a long sentence. The Supreme Court itself, the effect of all this in one short para, I will read. It is depressing to note that on account of such trumpery proceedings initiated before courts, innumerable days are wasted, which time otherwise could have been spent for disposal of cases of genuine litigants. Though we spare no efforts to fostering and developing a laudable concept of PIL and extending our long-arm sympathy to the poor, the ignorant, the oppressed, and the needy, whose fundamental rights are infringed and violated, and whose grievances go unnoticed, unrepresented, and unheard. Yet, we cannot avoid but express our opinion that while genuine litigants with legitimate grievances relating to civil matters involving properties worth hundreds or millions of rupees, criminal cases in which persons sentenced to death facing gallows under untold agony, and persons sentenced to life imprisonment kept in incarceration for long years, persons suffering from undue delay in service matters, government or private, persons awaiting disposal of cases wherein huge amounts of public revenue, unauthorized collection of tax amounts are locked up, detained, expecting their release from detention, order, etc., are all standing in a long serpentine queue for years with the fond hope of getting into courts and having their grievances redressed. The busybodies and middlemen, interlopers, wayfarers, officious interveners having absolutely no public interest except for personal gain or private profit, either for themselves or proxy of others, or for any other extraneous motivation or glare of publicity, break the queue, missing their faces by wearing the mask of public interest litigation, and get into courts by filing vexatious and frivolous petitions, and thus criminally waste valuable time of the courts, and as a result of which, the queue standing outside the doors of the courts never moves, with piquant situation creating frustration in the minds of the genuine litigants, and resultantly they lose faith in the administration of our justice system. This is the total effect of all this, as I have said. It is therefore necessary that judges must restrain themselves, whether in a PIL or otherwise, straying into the field of the executive. Now, having said all this, I should not be understood as implying that our judiciary is bad. Our judiciary is probably the best. Our judiciary has performed extremely well, particularly you compare it with the performance of the legislature or the executive. In whatever manner you see, our judiciary has done a great thing. And I will only refer to two judgments. One is Keshavananda Bharati case. Mr. Pai, Sudesh Pai is a great critic, and I am purely as a matter of law, the judgment was not correct. When the Parliament gave unlimited power to the to itself to amend the constitution, you put a restriction, judiciary. But the ultimate result today is good, because I feel, but for Keshavananda Bharati, if you look into the way our parliament and the legislators are behaving, particularly where they are in a absolute majority, I think if but for Keshavananda, we would not have had this constitution today. It would have totally disappeared and probably would have had. Therefore, though they have overstepped the limits, it has done good. But one judgment where judiciary is not only encouraged, but virtually, to use the expression, snatched away the power of the executive and invested that power with itself, is the second judge's case. In the second judge's case in 1993, by way of interpretation, the Supreme Court divested the ultimate power of appointment of judges to the High Court and Supreme Court and invested that power in itself. In fact, the Constitution, it doesn't require any great knowledge to see how Constitution was misinterpreted. The Constitution merely said President. President means aid and advice of Council of Ministers shall appoint in consultation with the CJI. So now the Supreme Court said consultation means concurrence. And then they said this power will be with the CJI. So a mere consultee became the ultimate authority, and that is how a very valuable power bestowed on the executive is taken over by the judges by way of interpretation. Virtually it is a case where they gave a judgment in their own favor. In almost all cases where it is judiciary versus so and so, judiciary has always succeeded. Only case where they lost was S.P. Gupta's case, where they said on a plain reading of section, it is the executive which is the ultimate authority. And now that was overruled very shortly by this 9-judge bench in the second judge's case. This is, not only this is wrong, after this, the Parliament unanimously passed the law investing this power with a National Judicial Commission consisting of Chief Justice and 2 judges plus a law minister and 2 eminent people to be selected by CJI, Prime Minister and Leader of the Opposition. These 3. Now, Supreme Court said, no, they don't believe or have faith even in the Prime Minister, Leader of the Opposition and CJI. They said, you may nominate any 2 persons, our independence is lost. Because it has become a good tool. Anything that they do, they say, if this affects the independence of the judiciary, which is a basic structure. What is a basic structure also? It is for them to say. It can go on changing. But the independence of judiciary is already accepted as a basic structure. It affects, therefore it is bad. So today, that NJAC Act and the 99th Constitution Amendment was struck down on the ground that independence of the judiciary is taken away. This is a totally wrong judgment, and it stands. Second judge's case and this NJAC case. These 2 judgments stand today and judiciary has taken over what has not been given to it by the Constitution. As Justice Bhagavati has once said, may not be exact words, it is not heroism to repeat a mistake, but correcting a mistake is the judicial compulsion. I feel, at least now, the Supreme Court must realize its own mistake and correct these two judgments by constituting a larger bench which will serve the cause of justice. Friends, in conclusion, I am only suggesting that, as I said earlier, if the executive or legislature goes wrong, judiciary is there to correct. But if the judiciary itself, as we say, Kannadದಲ್ಲಿ ಬೇಲಿಯ ಹೊಲವನ್ನು ಮೇಲಂತೆ, if the judiciary itself does it, then there is no remedy. Therefore, as our Supreme Court and American Supreme Court, some good judges have said, self-restraint is the only check on our power. So, judges must restrain themselves, particularly where a doubt arises whether they are encroached upon the field of the other two options. Thank you very much.
Thank you so much, sir, for sharing your thoughts with us. It is indeed an honor to have you here. I would now like to request our respected Dean, CMR University School of Legal Studies, Dr. Professor T.R. Subramanya, to kindly deliver the closing remarks.
Right from morning, 10:45 onwards, we have been listening to three or four important speakers. It may be relating to the law of sedition, or maybe the structural interpretation of the Constitution, maybe the director principle of state policy, and the two other speakers relating to interpretation and the doctrine of separation of powers. One important thing which, as the Honorable Speaker has pointed out, restraint is very much essential. Freedom is given, but then, when I remembered a quote which was made during the time of emergency in the Parliament. It was long back, perhaps on June 26th or so. Shamim Ahmad Shamim, he was the parliamentarian. He made a statement saying that I have the greatest detest for your opinion. That means I treat your opinion with contempt, but I shall fight unto death to preserve your right to express your opinion. So this is the meaning or the true freedom of expression. But then this expression should not go beyond a particular limit to harm the interests of the country, to harm the institutions which we have established. That everyone who makes the statement is supposed to be aware of. So the law of sedition, you might be knowing, the Honorable Judge has spoken about so many issues and made an analytical, gave an analytical approach to the concept. But then ultimately he was harping upon this matter only. Now certain things, remember, you are not supposed to speak. And if you are supposed to speak beyond a particular limit, naturally the courts will interfere. And when we speak about the directive principle of state policy, naturally the government is coming with up so many programs. And these programs ultimately for the benefit of all. And inequality you find in every legal system, even you have in the state of the United States, the best of economies. But then the corrective measures are to be taken and the government is elected for this purpose. But then there should be the least abuse. This is the fundamental principles that is being harped upon. Now when we come to the interpretation of the Constitution, whether it is structural interpretation or with this any other type of interpretation, which you know, those who have studied the interpretation, two things can be spoken. Now when we speak about the interpretation, yesterday in one of the interviews I was there, now can a prognostic type of interpretation be given to the provisions of the Constitution? Now when I mean prognostic type of the interpretation of the Constitution, simply means, now if I don't interpret and give this type of interpretation, the change of things which are likely to come, you will get affected. Whether the judges have this much of freedom, I don't think. So prognosis, suppose for example, an honorable judge when he sits, I am thinking only 50 years hence. So but this could be written in the judgment. But then at that time, the interpretation which is provided or with a literal statute had to be applied. But then when we speak about the literal interpretation in accordance with the words, naturally which gives a proper and plain meaning. In the event if it has not given a proper and plain meaning, it is the duty of the judge or judges to draw a proper meaning so that what is being interpreted is not to harm anyone, not to harm the society. Because the very purpose is to see that the existing system is carried on till an amendment or a change is brought about. That is the essence. And all the four speakers have spoken. Sir, we are beholden to you for giving such a wonderful talk. Although I am not a constitutional expert, now by reading what is heard in just 30 or 40 minutes, now we will be able to make this much. Honorable Sudesh Pai was a professor of law. He was holding a chair professor of law. Ashutosh Mukherjee is chair of law. Therein we came in contact at WBA NEJS. And I don't know, he is a senior lawyer and everyone knows it, but he was a professor also holding a chair. So these are the people who came to us, and these are the ones who enlightened us, and it is our duty to live up to these expectations and to remember, retain the provisions of the Constitution and not to abuse it. Thank you.